This is an appeal from a motion to strike and a motion for dismissal. In this new brave world that we're in now, since September of 2012 to December until now, all of us who do litigation have been placed to learn and put to learn all these new rules about emails and receipts and so forth. Since September 12th, in this case, it's a case that was prior to September 12th, it had been going on in the courts. There was no emails or anything, it's just the record below. From September 5th of 2012 to December 3rd of 2013, there was no activity on record. The first activity on record on that specific case that we're here today came on December 3rd, on about there, where the defendant filed a motion for dismissal. The motion for dismissal was filed and addressed in the certificate of service to the previous address of record, which had not changed. From the time that this was sent and just going through the mechanics of how this is filed, we have gone through a process of learning what gets filed. You go into the filing system, you have as of September of 2012, we all had to register a specific email and a secondary email with the Florida Bar. We all done that. I had 2 emails registered, and then through the e-filing portal, in order to start filing, we also register our emails. So when you file a document, as was done here on December 3rd of 2013, and they file this motion for dismissal, the rule says and require mandatory email to the opposing counsel. In this case, because of the previous case, and neither side, nor the defendant nor the plaintiff, have filed a designation of email with the court. But we were both registered with the Florida Bar, our emails. We both had the email registered with the e-filing portal.
But you apparently at some point, though, discovered this motion because you moved to strike it, correct?
Absolutely, Your Honor.
And then there was a hearing on not only your motion to strike the motion, but on the motion itself.
On
correct?
The motion itself, that is correct.
So before you got to the hearing on the motion, you at least knew enough about it to make a motion to strike it, correct?
Well, the problem, yes, Your Honor.
Well, hang on, I'm just trying to set up my question. So my question then is, how were you prejudiced in any of this? If at the time the motion was heard, you knew about it enough to make a motion to strike, and you went to a hearing that was set on the motion?
Absolutely prejudiced, Your Honor, because at the time, and this is why I explained it, on 2 occasions before we learned of this, the second time that they filed their motion, their notice of hearing on the motion in February 27th, again, they filed electronically, but did not email it. They mailed it. This was received by U.S. mail, and that's when we learned that the motion for dismissal had been filed. But we didn't receive the motion for dismissal at the time. We only got the notice of hearing. We requested the following day, I think it was a Saturday when it was opened the mail, and we received it. We say, hey, when do you file this motion for dismissal? I never got it. So on that day, on that Saturday, we filed all those pleadings. We filed notice of trial, we filed discovery, we did everything. We acted as soon as we knew. This motion, this notice of hearing was received by U.S. mail. It wasn't an email on the 27th. It was electronically filed by the defendant, but never emailed to us. We received it by U.S. mail.
So the actual motion itself, when did you have your hands on the motion itself?
On March 2nd, Your Honor.
And then when was the hearing on it?
The hearing was on on April 22nd.
Okay. So you had the motion itself, it sounds like 3 weeks before the hearing.
Correct.
How were you prejudiced?
Because the 60 days have begun to track on December 3rd. From December 3rd to March 1st, I believe it was a Saturday, that we received the notice of hearing. We had no knowledge that this motion had been filed. We had never seen the motion for dismissal. We had never received the motion for dismissal. And if they had done the emailing, as you were supposed to do according to the rule, we would have gotten this on December 3rd. We had no way of knowing. We acted promptly and diligently after the first, when we first got the motion. So the 60-day has expired, so that's the prejudice, because nothing could have been done within the 60-day window. And that's the reason why the court dismissed the case. I don't know if I answer your question. Now, again, going back to, because this is important, December 3rd, 2013, and from December 3rd, 2013 till February 27th, 2014. Again, a filing electronically filed notice of hearing sent by the same method by mail. This time it was received on March 1st, Saturday. We acted and did everything that I spoke to the court about. On 2 occasions, the defendant filed something electronically for the first time since the advent of the email requirement that came into effect in September of 2012. Nothing prior to that had been filed with the court. Electronically filed on December 3rd, 2013, and electronically filed on February 27th by the defendant. Neither one of them was email. Now, on those 2 occasions, the defendant had every opportunity to file an emailing a designation of email. He could have filed it then, because this was the first opportunity he had to file anything with the clerk of the court. No email designation was filed on December 3rd by defendant. No email designation was filed subsequent on February 27th by the defendant. So twice, and obviously, as ironically pointed out, they say if he had filed that, or if the plaintiff had filed that, we wouldn't be here today, because it would have been record activity according to the Kimrock case. So the only opportunity the plaintiff had to respond was after he received it on March 1st.
So the issue really doesn't come down to lack of email services. It's failure to receive the notice in time to act within 60 days under Rule 1.42.
That's a side issue, Your Honor.
And that you might have received the notice had there been email service. But what if you're not saying you received the physical copy in the mail of the motion or of the notice and disregarded it because it was an email?
No, Your Honor, no. It's as made clear in my affidavit.
That would be a pretty chancy
no, it isn't. It was not received. What we put in our affidavit is the only thing that we received was the notice of hearing on the motion for dismissal. Right. And we provided that in our affidavit. We stated to the court, on March 1st, we get this on a Saturday, and we respond immediately. And the following 3 days, on Monday, we say, hey, where's the motion? Because I got a notice of hearing with no motion attached. When do you file a motion for dismissal? And that's when we started, and we proceeded to file the other pleadings that we filed subsequent to that. But at no time, if we had received the motion, then I wouldn't be here making this argument, because then if the 60 days passed, and it was done. But, Your Honor, the email thing, I've been practicing 30 years, and the advent of email is a great thing, because you get it immediately. You have no way of saying or refuting, I didn't receive it. It's there. It's there. And if the email technology made it very well for lawyers, all you have to do is register. And I registered. My office was registered. The 2 emails were registered with the Florida Bar. The e-filing portal, in order to file, you have to also register. We were registered. If you go through the procedure of filing, when you push the button and you have the other attorney, you don't know his email. All you put is their name. It pops right out, email. And all you have to do is just put a little check mark, and it's immediately sent. Under the new rule says you have to verify that the email they have is the one that is registered with make sure that the email that you have is registered with the e-filing portal. And it was. So why go the wrong route? Why use the old ways? Nothing wrong with old ways, but why use when you could immediately, you don't even have to spend the money on the stamp. You don't have to put it on the mail. All you have to do is just click a button, and there, you serve the other side. If they say they didn't receive it, it's there. They got it. And with these new emails things, I have had cases where they wrote the email wrong. Prodigy, I think they put the E somewhere else, and I wasn't getting it. But the other attorney, when they send, they bounce back. They send me another email saying, your email is bouncing back, and they say, well, maybe the Florida court in Flagler County has it wrong. So we call over there, and we fix it. All these common problems are coming up. But if you have the rule that says it's mandatory, and if you have the technology that allows you to serve properly, why not apply it? That's why there's a similar case out of the 4th DCA that says we're going to enforce this email requirement and make sure everybody follows them, and we're going to strictly comply with them. If you have an email address, if you have the other side, and if it says you do 1, 2, or 3, there's a reason for that. You must do it. Otherwise, your motion is going to be a nullity. Your service is going to be a nullity. Now, there's another issue. And he said that it would be disingenuous for me to raise the issue if I'm claiming that I never received the motion. The motion in and of itself, and it was asked by the court, specifically in the hearing, does your motion comply with the rule as of 2006? Of course, I didn't receive the motion until the 3rd of March, or the 2nd of March of 2014, but it still argued thereafter, and it was wrong because it did not follow the rule. It said 12 months. It did not state that there was a 60-day window to file any pleadings. It did not do any of those things. So the motion, that in and of itself, should have been stricken for that reason, because the motion did not comply with the rule 4.20. So, again, the motion to dismiss that was filed was never received. It could have been emailed on the 3rd of December of 2013. It was not emailed. There was, and I pointed out on the record to the court, and I said, even though you could go through the portal system and get the email right away, and you could just call my office and get the email, you could check the Florida Bar and get the email, you could also look at your own file in this case, and you'll see that my last correspondence, which is in the court file, has my email on my letterhead. And this is the same email that I use. And this was on September 5th of 2012. So the reason is, if you have a rule, and the rule requires you to follow it, and it should be there in order to prevent this kind of cases, then the motion that is filed in violation of that rule should be and should have been stricken, and the motion to dismiss should not have been provided, because as the other case provided, is the case of Bushinger from this court, if you don't allow the other side the 60 days in order to allow the balancing act that Kimmel tried to bring, if you don't give them the 60-day window, because they never received the notice, because it was mailed, or it came back, or it was sent to the wrong place, then what's the purpose of 60 days? If you don't have any time to act. Simply, for that reason, I believe this court should reverse. And I'll reserve 5 minutes from his group.
You got it.
Good morning. May it please the court. I'm Stephen Ramuni, and I represent the Appellees, GNL, and Mr. Alvarez. I'd like to start by with what opposing counsel has just brought up today, and I believe that the characterization that he's presenting to the court today is not what he, in fact, raised by way of his affidavit back with the trial court, nor what he reflects in the record as being what happened. He's saying today, I never received this motion. What he raises with his affidavit is I never saw this. And I think that's an important distinction because we followed with the mailing and the fax what historically have been used for the proper service in Florida. So to stand today and say,
Well, actually, that's not what it says. His affidavit says, motion for dismissal has never been received in our office, in the U.S. mail, never received in our office by fax, never received in our office by email prior to March 3rd, 2014. So, you might say I didn't see it, but the reason you didn't see it, he says, because it never was received.
I understand, and it gets back to the original question, and I'll get back to that in a moment, but what we believe, what we followed as the trial court, Judge Lundy, ruled is that historically, mailing and fax was adequate service.
Well,
And-
let's just assume, let's forget, let's say the rule never changed. And he says, I never got it. Swears to it under oath. How should a court treat that in terms of his opportunity to have 60 days to engage in record activity?
Well, I believe under the mailbox rule, if I certify that it was mailed and the letter was not returned, and as an officer of the court, I would have a duty to inform the court that I did receive, because in the time frame from the original motion, which was in December, versus the notice of hearing in the latter part of February, it was approximately 80 days. So we did not receive in our office a return of mail. And the mail address that we used from this 2007 inception through the December 13 and in fact into the 14 timeline was the same exact address that had been on file with counsel all along. So to respond to Your Honor, we believe it was mailed, it was faxed, it was received. He says he didn't see it, didn't receive it, I understand. But the court ruled specifically at the hearing, I find that service was properly made as it relates to the mail, which historically has been adequate for service.
So you're saying the court made a credibility determination about whether they received it?
Yes, Your Honor. On page 33 of the record reflects the lower court referring to the fact that it had been mailed, and on the face of it, the court ruled that my motion to dismiss should in fact be granted because.
Well, did the court rule that it's not true that they didn't receive it? Or did the court rule that you mailed it and that's all that matters?
Well, the court referenced that it was mailed and that had historically always been good for service.
Well,
and it granted the motion to dismiss, yes.
With all due respect to the United States Postal Service, do they have a 100% rate of delivery? And I should advise you, I worked at the post office between college and law school.
you have inside knowledge of that.
I understand, however, we did not receive a return, nor have we received the return to today. And I'm not going to say absolutely it's not floating around somewhere, but historically, with the mailbox rule, it's deemed to have been mailed on the date of your certificate of service. So
There's a presumption that's created that it was delivered. The
Yes.
argument, I think, if I can follow Judge Northcutt, he has an affidavit that seeks to refute that presumption. And then there's nothing further. So at that point, then, is the trial judge has one piece of evidence that says, I refute the presumption, I never received it, there's nothing to contradict that, so that suggests a different outcome.
well,
As a matter of law, I'm
yes,
saying.
yes.
Outside the bounds of discretion, as a matter of law, should that
Well, and I understand, but the trial court was in the best position to determine whether or not the affidavit was founded or the argument of counsel at the time was well-founded, and the trial court chose to follow the route that the certificate of service showed it was mailed. Therefore, I'm granting the motion to dismiss. But I wanted to point out that, as you've heard, the case started in 2007, obviously, way before. Nothing happened. In fact, the last pleading was September of 2012, which was a pleading that opposing counsel did not register his email with nor file at the time. And as he's alluded to during his argument, it's been a learning process, but to say I was registered in the portal and therefore I didn't get it is, again, not accurate, and I don't believe the record reflects that, because when we file this by e-filing and you file it in the portal, if the attorney is registered through through the portal, that attorney's information automatically comes up through the portal. That was done by my office. Opposing counsel's email was not registered through the portal, nor had he designated an email address. Yes, he did have the designation through the Florida Bar.
But the thing is I think that gets to a different question. The question is, I think the argument is had all this email stuff been done, there would not have been the problem of him not receiving it by mail. But the question, the real nut of the question is did the judge conclude that he received it? And I don't see that in the judge's, statements on the record. All the judge said is, hey, there's a certificate of service said you mailed it, so I'm going to grant the motion to dismiss. I don't think that was the issue. So the question is like, if you mailed it, we go back to the old days, the good old days, I suppose. And you have a presumption that attaches to your, as a result of your certificate of service. I don't question that you mailed it. And you have a sworn affidavit by an officer of the court saying, I've never received this. What is the effect of that on in this instance, a 60-day safe harbor window, really?
Right.
That's kicked off by the serving of the motion.
Right. I understand that's problematic for...
And the judge never said he received it. The judge never said one way or the other.
No, that's true. However, the trial court did hear the argument of counsel. He did have the affidavit before him, and there's 30-something pages of legal argument on the motions to strike respectively and the motions to dismiss. So I have to obviously defer to the trial court. He didn't specifically articulate. I find he did receive it, but certainly when he granted and he referred to that it was mailed, and mail being adequate, I can't offer anything more than that.
Well, in
for
the
Your
old
Honor.
days, if there was proof that it was not received, all you get from the certificate is a presumption that it was received. The mailing in itself is one thing, but if it doesn't get received on the other end, that as a practical matter, the person doesn't get the notice and doesn't get the 60 days. And so I'm wondering if the judge stopped shy of where the judge needed to go in terms of making the determination of whether to dismiss his case.
And I can't answer that, Your Honor. However, my certificate does show mailed and facsimile.
Yeah.
So and that was historically what we had done in this particular case.
Right.
But it does come down to, and I think the central issue is a due process argument, and I'm aware of the case from the 4th DCA Mate, I'm not sure how you pronounce it, where it says you have to have strict compliance. But that case is clearly distinguishable from this case, because in that case, email was the only method of delivery, and the court found that the email was so defective in its formatting that it was a defective email or notice to opposing counsel. What we have here, we believe the Florida Supreme Court case of Vasillo versus Rosado that is actually cited in some of the cases that's raised by opposing counsel, addresses the due process question that the court would need to look at the particular case and the peculiarities of each particular case to determine whether or not due process was, in essence, afforded. Obviously, as the appellee and having the court grant the motion, we believe that due process was adequately afforded, and that the strict compliance ruling from the 4th DCA is not applicable in a situation because specifically under the Florida Rules of Judicial Administration 2.516, you have the subsection 1 which talks about service on the attorney, and I can see that, yes, we did not email this to opposing counsel. However, in subsection 2, where it says service by other means, when I elected to serve by mail and facsimile, we believe that due process was afforded. So under the particular circumstances of this particular case, we believe that the due process argument is in favor of the appellee, that it in fact was a situation, you know, as I know the court's quandary as it's raising, you have a person saying didn't receive it versus something that was mailed, but when you look at due process in totality, which is what the Florida Supreme Court case refers to, we believe under the totality of the circumstances, there was adequate notice made with regards to the motion to dismiss. And as was argued earlier by opposing counsel, any deficiencies from the motion to dismiss were not raised at the trial court level. They were not raised with regards to the argument before the court today. So we believe that to say today that the motion was defective or there was some problem with the motion, that was not preserved properly for appellate purposes. So respectfully, we believe that under the totality of the circumstances and what the trial court had before it at the point in time when these respective motions were argued, that due process was afforded to the appellant as had been done from this case from inception. So respectfully, we would request that the court uphold the lower court's ruling as it relates to both the motion to strike and the motion to dismiss. Thank you.
Okay, thank you.
May it please the court. The fundamental question, as Your Honors asked, is was the 60-day window provided in this case? It was not provided. The motion was never received until the 3rd when it was seen by email, as pointed out in our affidavit. The question is that due process? If you don't have a chance, an opportunity to avail yourself of a 60-day that's provided under the rule, not because he failed to put it in his own motion, which, by the way, was raised at the time of the hearing that his motion was, it was raised by the court. The court asked him if he had followed the rules in the motion, and he said he made a mistake at the time. He said no. He said yes, it had been filed, but it hadn't been followed because it didn't say 10 months, it didn't say 60 days. It simply said 12 months. This is an old motion probably that he had. But the fundamental issue, again, Your Honor, is the motion was not received. There was no opportunity to act until the 3rd. Until after. The first was when we get the notice of hearing, and we did all the pleadings on a Saturday. They fell on a Saturday. And the following day, 2 days later, we see the motion for the first time. So the 60-day window had gone, so no opportunity was had. That's not due process. And I ask this court to overturn the motion to strike, the denial of the motion to strike, and to set aside and overturn the motion to dismiss.
Thank you, Mr. Cervantes.
Thank you.
Thank you. Court will be in recess for 15 minutes.
technology at work. Or about to lose power.